What is legal pluralism? According to Griffith, it is generally defined as a situation in which two or more legal systems coexist in the same social field, as every functioning subgroup in a society has its own legal system, which is necessarily different in some respects from those of other subgroups. So why is it related to Malaysia? Well, the answer is because Malaysia practices the dual legal system, implementing both Sharia and civil law.
In Malaysia, ethnic and religious pluralism goes hand in hand. Pluralism affects all factors of society. Obviously, it creates tension, but all the same, Malaysia is remarkable as an example of how different ethnic and religious groups peacefully live side by side. What makes this pluralism issue noteworthy is not merely the fact that there is multiple uncoordinated, coexisting, or overlapping bodies of law, but there is diversity amongst them. The legal regime dealing with divorce and marriage in Malaysia is pluralistic in nature. The legal pluralism takes several forms. In the first instance, different systems apply for Muslims and non-Muslims in family and matrimonial matters. Laws on these matters are legislated separately. For non-Muslims, they are legislated and administered at the federal level, whereas for the Muslims, on the other hand, individual states have jurisdiction to regulate and administer such matters. In this documentary, we are here to explain how pluralism affects different areas of our society, particularly on converting children to certain religion, focusing on custody rights of separated parents by different religion in Malaysia. In Malaysia, child custody is governed by two separate laws. For the non-Muslim, it is the Law Reform Marriage and Divorce Act 1976, while for Muslims, they are the Islamic Family Law enactments for the respective states and the Islamic Family Law Act for federal territories. In determining the custody of a child, both Islamic law and civil law agree that the paramount consideration is in the interest or welfare of the child. For instance, Islamic and civil law consider the age and the gender of the child's preference, if the child is of an age to express an independent opinion, the parents' capability of raising the child, and the conduct of the parties. Problems arise when one of the spouses in a marriage converts to Islam, because conversion is recognized as one of the grounds to dissolve marriage by both Act and the Islamic family law enactments. Also, when one of the parties is a Muslim, both judicial systems in Malaysia have jurisdiction on the matter, thus causing a power to overlap. Contradictory rulings by the civil and Sharia courts in child custody cases can complicate matters of justice. With that being said, issues pertaining to the custody of a child of separate parents shall be discussed to present the existence of pluralism in the Malaysian legal system.
Under the Sharia law, the courts will always make the best interest of the child as the central theme of child custody arrangement, as it was provided under Article 121, Clause 1A of the Federal Constitution, where it stated that the Sharia courts have jurisdiction over a person who are professing the religion of Islam in respect only on certain specific matters of Islamic law, such as a divorce between Muslim couple. Because the provision of Article 121(1)(a), the civil courts should not interfere with one party, comes to the civil courts after losing a case in Sharia courts. In the case of a child custody, the Sharia courts practice the sole custody approach to adjudicate custody disputes. Through a court order, sole custody is awarded to the parent who is considered better and more fit with the child. Thus, the custodial parents gain child custody, while the non-custodial parent is granted visitation and overnight rights. Moreover, Section 81 until 87 of the Islamic Family Law Act, Federal Territories in 1984, which is after this we would refer it as IFLA, contain a number of rules relating to issues of who is eligible for child custody, what requirements must be met for child custody, and visitation right. The parts also cover the condition under which the right to child custody is lost, the length of child custody, custody of children born out of wedlock, the court's authority to order child custody, and the circumstances under which court orders are subject to condition. In sharp contrast to Malaysian civil courts, Sharia courts use religion as the criterion for deciding a child's well-being in child custody matters. The civil courts do not operate in this manner. According to the article entitled Shared Parenting versus Sole Custody in Malaysia, Sharia Court Lesson from COVID-19 in 2021, it explained that there are 5 elements evaluated by judges before educating, namely, the first one is retaining the status quo of the children. The second one is fulfillment of the children's essential. The third one is attitude and morality of the custodian. And the fourth one is the emotional status of the child. And the last one is the choice of the child. However, these factors are not in the form of written law, and since Sharia courts do not practice the principle of stare decisis, they are only used on a case-by-case basis, as they are not construed. At the same time, these elements may act independently or together as compounding factors. Conveniently, they are open to judges' discretion and make judgment in trials. Subject to Section 82, there is a presumption mentioned in Section 81, subsection 1 of IFLA, stating that the mother shall be all person, the best persons, entitled to the custody of her infant children during the conjugal relationship as well as after its dissolution. The presumption is made based on the mother's loving and caring nature towards her children. Currently, when it comes to child custody, Sharia practitioners and judges must translate Section 86 of the IFLA literally. According to the IFLA Section 86 subsection 1, particularly, Section 86 saying that court's authority to issue custody order is, the first one is, despite Section 81, the court may at any time by order choose to entrust the child to any of the individuals named therein, or in the event that exceptional circumstances make it undesirable for the child to be entrusted to any one of those individuals. The court may by order entrust the child to any other individual or to any other association, the purposes of which include child welfare. The court's decision-making is constrained and given tunnel vision by the literal translation of the phrase any one of the person. It also translates as into sole parental responsibility with the previously indicated right of visitation for the non-custodial parents. Even though it would seem like Sharia courts are the only places where sole custody is used, joint parenting is really more common than the sole custody. The right and obligation of parents always come in two, regardless of whether the parents are still married or not. There is also overwhelming evidence that the Sharia courts place great value on a child custody related issues resolved amicably. Most crucially, despite the fact that there is no explicit legal authority for a judge to mandate shared parenting, there are several present laws that fall under the purview of Sharia courts and that obliquely allow for shared parenting through consent judgment.
By virtue of an amendment to the Federal Code, that is Article 121, Clause 1A, which came into force on 10 June 1988, the civil high courts in Malaysia has no jurisdiction in respect of any matter that falls within the jurisdiction of the Sharia courts. The statute governing non-Muslim marriage and divorces in Malaysia is the Law Reform Marriage and Divorce Act 1976, hereafter LRA 1976. This act specifically includes its application to the person professing the religion of Islam. Section 51 of the LRA was intended to address the dilemma created when one spouse converts to Islam and the other does not. This section enables a non-converting spouse to petition for divorce in the civil courts against the converted spouse on the ground of conversion to Islam. In essence, it preserves the right of the non-converting spouse to seek ancillary reliefs consequence upon a divorce against a converted spouse. In the eyes of civil law, married to the converted spouse until divorce is sought and granted pursuant to a petition for divorce initiated by the non-converting spouse under Section 51 of LRA 1976. The example case for child custody of separated parents by different religions in Malaysia is in the case of Shamala Satya Silan versus Dr. Jaya Ganesh. This case is about a Hindu father converted his two sons, aged 3 and 2, to Islam without the mother's knowledge or consent. The mother filed an application in a civil high court for custody, care and control of the two boys. two boys. The father moved the Sharia court for an ex parte order for custody of the children. On the date fixed for the hearing of the custody application, the father obtained a postponement so he could appoint solicitors. On the urgent date of the hearing, the Civil High Court, after hearing submission on preliminary point, ruled that the Civil High Court, following the earlier Supreme Court case of Tan Sung Moy, retained jurisdiction to hear the matter. An interim order was thus made, leaving the children into de facto care and control of the mother, with access to the father pending final determination of all issues. Subsequent to and despite the existence of interim order of the Civil High Court, the father proceeded to the Sharia High Court and obtained a final order for the custody of the two boys. The Malaysian Civil High Court heard an application by the wife for declaration that the conversions of her two children to Islam and those of her husband are null and void, as they were made without the knowledge of and the consent of the wife, the natural mother, and the other parent of minors. The wife also made an application for custody, care, and control of these fathers to be ordered to be paid for their maintenance. Article 12, Clause 4 of the Federal Constitution gives a minor parent or guardian the right to determine the religions of the minor below the age of 18 years, and Section 5 of the Guardian Infantship Act gives a mother the same rights and authority as the law allows the father in the custody of upbringing of an infant, and the right and authority of the mother and father should be equal. Infant is defined as a child below the age of 18 years if Muslim and 21 years if a non-Muslim. The High Court judge dismissed the application for the declaration sought by the wife. In his ruling, the judge held a view that the consent of a single parent is enough to validate the convention of the minor. The Sharia court was the only qualified forum to determine the status of the two minors, notwithstanding which the wife had no right of audience before the forum. Father and mother have been awarded joint legal custody of their two children with care and control to the mother. The father was granted visitation rights and ordered to pay maintenance. The mother has appealed the earlier decision dismissing the declaration sought, and the father appealed the latter decision of custody. The mother and the two children have in fact disappeared from the jurisdiction. Thank you.
According to Section 81 of the Islamic Family Law Act, custodianship rights of minor is with the mother whether during the marriage or at the time of dissolution of marriage, even though the mother has the utmost rights upon the children compared to the father. Section 82 further explains that among the prerequisite condition required is that the mother has to be a Muslim. Furthermore, Section 83 of the same Act explains the mother will lapse her capability of custodianship if she is not practicing the Muslim religion or becomes an apostasy. The legal provisions show that if the mother is a non-Muslim, the converted Muslim father's rights to gain legal rights upon the child will be considered by the court. Moreover, in Islam, fathers are held responsible to preserve his child's religion or hifzuddin based on one of the Maqasid Sharia principle. Issue to safeguard the child's beliefs as well as shahada is related with the issue of religion conversion as well. This argument would normally be based on the provisions in Article 12(4) of the Federal Constitution, which by its wording provides that the religion of a person under the age of 18 years shall be decided by his parent or guardian. This means that either father or mother has the right to determine the child's religion, and this includes converting the child to Islam without having to get the consent of the other parent. It is therefore reasonable, in the case of involving parents of a different religion, that any person who has been given the right of custody shall also have the right to determine the child's religious upbringing.
Law, Article 11, subsection 1 states as follows: every person has the right to profess and practice his religion and, subject to Clause 4, to propagate it. Furthermore, in Malaysia, generally, Article 12, subsection 4 of Federal Constitution safeguards the right of religious freedom for children below 18 years old. For non-Muslims, Reference can also be made to the Guardianship and Infant Act 1961. The Section 5 under this Act reads that in relation to the custody or upbringing of an infant or the administration of any property belonging to or held in trust for an infant or the application of the income of any trust property, a mother shall have the same rights and authority as the laws allows to a father, and the rights and authority of mother and father shall be equal. The mother of an infant shall have the like powers of applying to the court in respect of any matter affecting the infant as are possessed by the father. This is because there are real cases as where a mother who is not a Muslim face ambiguity in custody and religion rights towards her own children. Reason being, Sharia law and civil law construe the matter differently, though both stress on the welfare and well-being of the child as the paramount consideration. In an attempt to resolve these struggles, the government proposes an amendment to the law, Reform Marriage and Divorce Act 1976 in November 2016. The amendment of this LRA Act has just been passed in mid-August 2017 with certain modifications to the earlier proposed amendments. The amendment will empower the civil courts to resolve matters related to the dissolution of the civil marriage between the parties, regardless of the fact that one of the party is not a Muslim and constitutionally would not be bound by the civil court jurisdictions in matter of family. During the first reading of this bill tabled in November 2016 by the Minister to amend the LRA 1976, a new section 88A was proposed. This proposed new section 88A states the need for both parties in a civil marriage to give consent for their children to be converted to Islam before it can occur. The proposed section 88A of the LRA is to be given retrospective effects even for cases which are still pending in courts. It is argued that such move to amend section 88A will be contradictory to Article 12 subsection 4 of the Federal Constitution, as well as the Sharia principle. It creates avenue for non-Muslims to exercise their rights, while Muslims might be denied the right to practice the true teachings of Islam. However, every citizen should respect the other's right in order to maintain the stability on the country.
For me, pertaining to the theory of pluralism in Malaysia, we can see from the implementation of civil law and Sharia law in Malaysia. And from the perspective of a layman, this theory in Malaysia is very difficult to understand. This is due to the fact that the immersion of Sharia law into the legislation in Malaysia is very weak, especially when there is conflict between Sharia law and civil law. Perfect example is seen to the conversion of a Muslim from Islam. Under this matter, it has been issued whereby the jurisdiction of these courts pertaining to this matter is still in the grey area. Some people may questioning why Sharia court has the power concerning to the faith of a non-Muslim, let alone this matter is profoundly involving the matter of someone's faith in God, not just a matters of legal action. However, as we are discussing the conversion of a child in Malaysia, it is still a grey area for me, especially for the children who had parents from different religions. We can see in the situation sometimes the converted spouse even files for a divorce in Sharia court, resulting the two divorce settlement, one from the Sharia court and one from the civil courts. This alone leads us to difficulty, especially for the children themselves. It is based on the view of ordinary people who do not know or even understanding the law or any kind of it, to think that the distribution of such jurisdiction is somehow confusing and very difficult to understand. When one of the spouse convert to Islam or convert away, it happened that he or she tries to unilaterally convert his children to his religion also, and this will also raise a great issue among the family members.
Apart from that, when an individual converts to Islam, the application of legal pluralism, particularly the various set of personal law that's applied to Muslim and non-Muslim, puts converts non-Muslim family members and religious authority in difficult legal situation. Furthermore, because religious institutions do not currently offer legal literacy program, some Muslim converts are unclear on how to proceed when dealing with legal issue. For me, The legal labyrinth created by one parent's unilateral conversions of a child and its influence on a parent's parenting rights has produced social tension and ethnic discord over the years. If we see that both Islamic and civil law agree that the fundamental issue in determining custody of child is the child's interest of well-being, factors to be considered in assessing the best interests of the child are similar in Islamic and civil law except in the subject of religion. Although personal matter for Muslims should be heard in Sharia court, in circumstances of convictions, civil court will be the appropriate court to hear such proceeding. Because Article 8 of the Law Reform Marriage and Divorce Act 1976 says that a marriage is solemnized under the Act, any application dealing with the civil marriage, such as the dissolution of the marriage and other ancillary relief, must be made in civil courts. Furthermore, because the Sharia court jurisdiction is limited to non-Muslim, it will be unjust if the parties were unable to present their complaint before either court. In considering the fact that both parents will be evaluated by the judge to evaluate their capacity to care for the children, the best interest of the child would be the appropriate method to decide on religious upbringing, and this alternative is not in conflict with either civil or Sharia law. In the case that the process is not adhered to correctly in terms of compliance, this could lead to a tug of war.
Another debatable aspect of unilateral conversion is whether this is the best solution. This issue gained mainly attention when the federal court decided in the case of Indira Gandhi that both parents' consent was required in determining the minor's religion. It is laid down in Article 12 Clause 4 of the Federal Constitution that the word parent refers to both the father and the mother. In Islam, Muslim jurists have held that when both parents has converted to Islam, their underage child will automatically become Muslim. However, issue will arise when only one of the parents converted to Islam, and this has sparked several interesting and jurisprudential debate. The majority view of Hanafi, Shafi'i and Hanbali schools revolves around whether the convert was the mother or the father. Interestingly, Maliki school has a more direct approach that the child's religion will be determined by their father. This is because the identity and the lineage of their descent are through the father. Even so, there is no final authoritative view as there are no clear-cut Quranic verses addressing the matter. The current situation in Malaysia is that there have been several cases where a father or mother embraces Islam and converts their child even before the custody of the child was resolved by the court. This would undoubtedly create future problems. Therefore, it was suggested by Dr. Muhammad Azam Muhammad Adli, who was recently appointed as the head of director of Institute Kefahaman Islam Malaysia, that the determination of a child's religion should take account of the custodianship of the child by prioritizing their welfare. A comprehensive cooperation between the guardian, parents and authorities is needed, as the issue could be solved through a mediation process that would be facilitated by a third party. For that reason, International Institute of Advanced Islamic Studies, Malaysia proposed several policy reforms in its above-mentioned policy papers relating to conversion in interfaith marriage. Among the recommendations were, firstly, the child's welfare should be the top priority and the ensuing responsibility by the disputing parents. Secondly, establishing a particular branch of the judiciary containing both civil and Sharia jurisdiction where both judges sit and solve the case together. The last one would be to set up a judicial committee containing a majority of Malay rulers with composition of Muslim and non-Muslim, as well as involving female members in the committee.
According to the issue, the court is more cautious in deciding the child's religion and custody because of the complications that arise when there is conversion by one of the parents. When this problem is settled in the civil courts, there is a consistent decision-making process. It is seen as fair that the government has rules on the rights to convert the religion of a child, and such laws are believed to be fair in the country. In addition, A child usually cannot be forcibly converted to another religion by either of their parents. It is necessary to have the agreement of the child's mother as well as the child's father. Given that religious authorities' perspective on this matter do not appear to be consistent with one another, it is imperative that they respect and adhere to the supreme legal system that is already in place in the country as well as the civil courts, which are the venues in which issues of this nature can be resolved peacefully. A Quranist, Sheikh Akbar Ali, who is also a well-known blogger, said, "This is an example of diverse theological interpretations. It would appear that the interpretation of religion is constrained or determined by the political jurisdiction. This means that the meaning of religion may vary from one state to another state, and even from one country to another. Furthermore, the various sections of the religion each have their own unique approach to understanding the religious text. Therefore, there is no coherence in the various ways that religion might be interpreted. On the other hand, civil courts adhere to a single body of law that is more transparent, logical, scientific, and consistent. They are more applicable to all situations. There will be no uniformity and it will become more problematic. When religion is subject to the interpretation of religious authorities, this leads to no definitive solution to difficulties, especially the question of custody and the unilateral conversion of underage children.
To summarize, how civil law and Sharia law deals with the religion of parents who have different religions overlaps with one another. For example, in the eyes of civil law, Section 51 Law Reform Act 1976 shall be referred to when addressing the dilemma created when one spouse converts to Islam and the other partner does not, and preserves the rights of the non-converting spouse to seek relief upon the divorce against a converted spouse after giving the non-converting spouse a petition to divorce. Moreover, in accordance with Section 5 of the DIA, a mother has the same legal rights and authority as the law recognizes for a father when it comes to the custody or upbringing of a child, and the rights and authority of the mother and father shall be equal. Moreover, Article 12, Clause 4 of the Federal Constitution grants a minor's parents or guardian the right to decide the religion of the minor under the age of 18. Meanwhile, under Sharia law, Section 81 until Section 83 explains that the mother will have custodian rights, which she must be Muslim for, and will only lose her custodianship if she is not professing Islam or becomes an apostasy. In deciding what religion the minor will profess, it will be referred to the provisions of Article 12, Clause 4 of the Federal Constitution, which states that a person under the age of 18 years must have his or her religion decided by his or her parent or guardian. One must not attain the other spouse's consent if they are to convert the minor to Islam.
In general, in the issue pertaining the custody of a child of separated parents, Sharia court is more superior and has more jurisdiction compared to civil law, just like stated in Article 121 subsection 1A, where the civil court should not interfere when one party comes to the civil courts after losing a case in Sharia courts. Furthermore, Sharia law touches about the rules relating all the requirements that must be met for child custody in depth. However, looking at one of the issues stated above, which of the parents and how the divorced parents by different faith decide a religion for their children, should we look at the case of Subhashini Rajasingam and Saravanan Tangatore and other appeal, where this case concludes that only the consent of one parent should be required in future circumstances. However, with the proposed Section 88A amendment, the religious status of a child after marriage will be more complicated. To conclude, the application of legal pluralism, specifically in the issues of a child of separated parents by different religion, does not provide a crystal clear statement, as there are various sets of personal laws that apply to Muslims and non-Muslims. Following that the parents' capacity to have guardianship of the children will be taken into account by the court, we believe that the matter of the child's religion should be based on the religion of the custodianship parents.
So, how do you feel about your husband's action and also with the court's judgment?
At first, I was really frustrated at my husband because I believe I also have the rights as the mother of my children to decide their religion. I was so shocked at first knowing that they all already converted to Islam. I didn't agree at this at all. But right now, I need to see the justification and the rationality of the decision by the court. So I think I need to find out more about this and get to know the reason really good, so that my relationship with my children will not be completely gone after they're converted. So yeah.
Okay, so do you know what is going on currently?
Between our parents,
Yeah.
I would say that it's really confusing for us children because we are in a dilemma on which side of our parents should we be following. So right now we're just staying with our grandma and we're waiting for any decision that is held by the court towards us as the children.
Conversion.
So we have never learned about Islam before, and I don't know, we are wearing this shawl just because our dad told us to do so.
So all of you guys' life after the conversion.
After the conversion, our life become a bit confusing because suddenly that put us at kafar to learn about Islam, and like what Akidah said, we were told to wear hijab, and we were told to learn how to recite Quran and everything. It's so confusing.
How do you feel?
I'm a family leader. I have a right to determine what is the best for my family. And I want to bring all my children to the Jannah with all the laws of Islam. That's it. I don't care what happens in my family. Of course, because I have the right. It's a legal family.
Some comments about the issue that you are handling.
In accordance with what has been ruled by the courts, based on the doctrine of binding precedent of previous judgments, the court stipulated that the word parents refer to themselves as one as the only requirement, and not that both the parents should be statements. So, with regard to the right to determine a minor's religious freedom under Article 12, Section 4, there seems to be a need for a clearer interpretation to avoid further and prolonged confusion in order to achieve justice between the parties.